Welcome to AlteaTalks, the brand new podcast series being brought to you by Altea, the unique provider of combined insurance and risk management solutions designed exclusively for the medical, allied health and care sectors. I'm going to be your host, Will Marshall, and I'll be joined in this series by some of the leading movers and shakers from across the sectors. My guests are going to include practitioners and professionals, regulators, clinical risk and governance specialists, and an array of legal experts who are going to help us get to the heart of the hottest topics affecting the UK's health and social care sectors today. So, if you're looking for frontline knowledge and expertise, if you want valued insights into these most dynamic, challenging and rewarding of sectors, then look no further because you're in the right place. Welcome again to AlteaTalks. Hello and welcome to the inaugural episode of AlteaTalks, our brand new podcast series. I'm Will Marshall. I head up Altea Plus, our specialist risk management service here at Altea Insurance, and I'm really excited to be launching this new series today, where I'll be talking to a whole host of guests to explore some of the pivotal regulatory, legal and insurance topics that are impacting on the health and social care sectors in the UK. I'm very pleased today to be joined by my former colleague, Vicki Swanton, to discuss issues relating to informed consent. Vicki is one of the UK's leading healthcare lawyers and heads up the very well recognised healthcare team at DWF. Vicki has recognised expertise in representing healthcare providers and has been doing so for some time now. I won't put a figure on that. Vicki works widely with both public and private sector healthcare providers and is a leading national expert in defending clinical negligence cases of all shapes and sizes, especially with particular expertise in dental cases. Vicki is well recognised within her sector for her holistic approach to the interrelated issues that an adverse healthcare event can generate. And I'm very pleased to be joined by her today. Welcome, Vicki.
Thanks very much, Will. And it's great to be speaking about the topic of consent, which I think a lot of us feel is a very basic requirement. It's all about communication, and it's surprising how often it goes wrong. So it'll be good to talk about those experiences so that those that are listening to this podcast can take something away that hopefully is helpful for them in their day-to-day practice.
Absolutely, thank you. And so in relation to consent, obviously consent is a fundamental part of the healthcare professional's job and also of the patient experience. Sadly, as we both well know, it's also a very common feature of complaints and legal claims against healthcare professionals. Vicki, can I just ask you to start things off? Why is consent so important in the medico-legal world?
So we all have the right to, as they say in those legal textbooks, medical body integrity. And so you have the right to refuse treatment. And I think most of the interactions that we all have when we're in that patient seat, we're going knowing what we want to have done, the treatment we require, but we rely on the individual on the other side of the desk, if you like, to tell us what our options are and what the treatment could entail and the risks and benefits of it. I think one of the challenges is that we learn a lot through Dr. Google, think we know what all the risks and benefits are, but we really don't. And we rely on the practitioner for those range of interactions that we'll be having with them. And I'm conscious that people listening to this podcast will do a range of different treatments. We could be talking about somebody who vaccinates. We could be dealing with a person who is involved in more aesthetic treatments. So all fillers, procedures, or we could be dealing with someone who's carrying out extractions as a dentist or spinal surgeons and the whole range. And obviously the amount of information that patients are entitled to and should be asking, because it's a two-way process, varies significantly. And we've got those pressures of patients waiting to be seen or clients in the waiting room. And sometimes I think practitioners do feel that time pressure. But I think the seats that we sit in, well, with regard to looking at events after things have gone wrong, you often feel if only someone had taken that time, they might now not be having to speak to a lawyer or their insurer about a problem. So I suppose that's why it's important. It's a basic part of all interaction with a healthcare practitioner. And we've seen it go wrong, sadly, too many times. And I think if people can take away anything from this podcast, it would be that communication point and taking time and making sure that the individual that is effectively allowing you to treat them understands their options and the risks.
Yeah, thank you. I mean, you've touched there on the legal implications of the consent process. I think it would be helpful for the listeners if you could give us a brief overview of the current legal framework that governs consent in England and Wales in 2023, because obviously we've had some fairly significant recent case law that has got all of us lawyers excited about it. But it would be helpful, I think, just to share your views about where that leaves practitioners and patients from a legal perspective.
Of course. I was not going to actually name the cases initially because I thought that would mean that people would effectively stop listening. But the most recent case, I'm going to take that first. It's actually called Mulloch, but I think it's important to deal with that case first because it really dealt with options. And I think options comes first for me. If I'm the patient, I want to know what my choices are. And I think, again, we need to always consider that one of the options, and sometimes practitioners forget to mention this, but it is arguably to do nothing, not to interfere, not to intervene. And then you've got that whole range of conservative measures then going through to surgical. And we do have, I think, sometimes a challenge of patients doing the Dr. Google and ending up with a very long list. And it may be as a practitioner, you are only skilled in offering one or two of those potential options. But I think awareness of what could be out there and where that patient could go if they wanted to pursue other options is actually also a responsibility. But what you don't need to do is have on that options list 20 possible ways of dealing with a fracture, for example. That isn't required. And I think it is important, and this is what the Mulloch case identified, that I think we're all experiencing that information overload. And there is a recognition that too many choices can be unhelpful for patients. So, for example, were I to be a dentist looking at a patient where I'd identified decay, there may well be a multitude of ways of treating that. But what would a reasonable dentist do standing chairside next to me as a patient? Well, they'd identify what those reasonable treatment options are. Okay, I can do nothing. You'll be in pain. Not a great idea. Or we could effectively drill and fill that tooth. So I think it can be quite frightening being a healthcare practitioner with the responsibility. And we know that lots of treatments come out all the time and some are wacky and some are more conventional. But it's really where we are now is the law recognising that practitioners have to act in a way in terms of options that a reasonable or responsible practitioner skilled in that art, as the lawyers would say, so who can stand in my shoes, would accept that I'd given the patient the reasonable options based on where their clinical condition is.
Yeah, no, I thank you, and I think the whole question of clinically appropriate, reasonable alternatives and where you practically draw the line as a practitioner is an area of continuing uncertainty in the light of the Mulloch decision. Various examples would be if a patient is attending a hospital or a facility which may not offer a specific treatment, is there still a requirement on the professional with the practitioner within that hospital to make the patient aware of that. It may be, for example, that it's a patient attending on the NHS and that particular treatment is only available on a private basis. And I think there are a few grey areas around that. Another example that occurred to me would be if, for example, a patient coming in for a hip replacement wanted to know about what sort of detail should be shared about that treatment. Do you need to go into the different types of prosthetic devices that are available? Probably in the light of the hip litigation, you probably do. But again, it's where you draw that line. I think, but the point being, that is a decision for the clinical judgment based on the expertise and experience of the healthcare professional.
Yes, and I think we also need to caveat all of that with the recognition that you can only be expected to give those options that are relevant at that point in time. Again, my role is often to come in and advise after things have gone wrong, and the notification typically comes 3 years after the event. So don't worry. We all know that treatment moves on. It's really what was reasonable at the time. But I agree, it's not an easy process. And I do come back, though, to the court did recognise the need not to bamboozle patients. I say patients, clients, same label applies. So what's reasonable and responsible with regard to the range of options at that point in time based upon the person they're sat in front of. So, for example, we know that there are different specialisms in dentistry. I come back to that example. And the range of options that an endodontist could offer a patient would be very different to a general dental practitioner. So I think that's the other reassurance, if you're listening to this as a practitioner, that you should take away from it.
And that's based on the decision in the Mulloch case. Of course, the first or the other key decision on consent was the Montgomery case back in 2015, I think, from memory. And Montgomery put more onus on the professional tailoring their advice as to the material risks for the specific patient, didn't it?
It did. And I mean, anybody who wants to sort of go away and look at that case, I think you'll read it and be disappointed, I think, in how the patient received advice. But the way I think the case then progressed and the decision that was made was the right one. And I think it really has improved the communication between practitioners and patients for the better. So I think a sad day that it required that particular patient to take it so far to get that judgment. But I think it is really, really important now for practitioners when they're setting out options to evaluate for that particular patient the risks for them. And examples can be given such as if you're doing an aesthetic procedure, for example, if the individual who is in front of you is a model, then clearly they are going to be much more affected by a procedure if it goes wrong, because it will impact their earnings, their whole career. And so the sort of way that you would approach the options and risks, I think, would be very different. The same for a hand surgeon dealing with a pianist. It's very important to tailor your advice on risk to the individual. And that, I'll come back to the first thing I said about communication. How can you do that if you don't speak to the individual and find out why they're in front of you, what their problem is, and then as you talk through the options, what's important? Because you can't assess that just by looking at someone. You've got to have the conversation. And again, I think I'd reassure practitioners that this isn't a one-way street in terms of looking at options and risks. The patient has a responsibility too. And that's also something that I think the case law is increasingly recognising. When people read about Montgomery, they'll hear about practitioners being paternalistic and trying to make judgments for patients without involving them. And we've now moved into a world where we have shared decision-making. But I think that's a good thing. I think that interaction and discussion so that what we go forward with in terms of a treatment is something that both parties have talked about, discussed and are aware of. And I'm sure, Will, you'd have had cases where things that have gone wrong, the patient will then turn around and say, but you didn't tell me that. And the practitioner will often say, yes, I did. You just didn't hear it.
Absolutely. And I think a good example of, I agree with everything you've said, and a good example of how a particular concern may be of relevance to a particular patient occurred in a case that I handled a couple of years ago, which was a cosmetic surgery case, which involved allegations of a failure to obtain informed consent, not because the surgeon hadn't properly explained the risks and potential risks and benefits of the intended surgery, but because he had failed to inform the patient that he would not personally be performing a particular aspect of the surgery. And although we never actually contested that point, the case was resolved for other reasons. It raised a very interesting point because the surgeon said that it was very common practice when doing these multi-site, very long, complex procedures to have a surgical team, and it was entirely reasonable. In fact, it would have been negligent for one particular surgeon to have been performing surgery for the duration that this would have taken. But the issue there was that going back to your Dr. Google point, was that the patient had specifically researched this surgeon. She had picked him out as being the person to do this work, that she wanted to do this work, and he had not shared the information with her in advance that he would not personally be performing each aspect of the surgery. So again, it raised an interesting, for me at the time, pretty novel issue around materiality and around the specific concerns and intentions of this patient.
I think it also raises that challenge of the person who's carrying out the treatment, making sure that the client patient understands the risks, rather than relying on the fact that a colleague may have seen them first and gone through what the procedure involves. And I know that in some clinics, there may be, for example, a receptionist or a treatment facilitator who will discuss with the client, okay, you've come in today, it's an elective procedure, or to take them through the details, what's involved. They may indeed say who's going to be doing it that day. And then the practitioner arrives. And it can be very tempting to think, right, okay, yes, receptionist has done their job. They wouldn't have got to see me if they hadn't. And pretty much then start the procedure after the pleasantries of, hello, how are you? But anybody who is putting a needle into someone else, doing anything that's invasive in that way, laying hands on another individual, needs to be sure themselves that that person has agreed to that treatment. So I think it goes to that issue of making sure, if you're a practitioner, that you don't assume that someone has done that whole evaluation of options, risk, benefits for you, that you're confident that the person in front of you does understand, because at the end of the day, as the Americans would say, the buck stops with you.
Absolutely. So based on the law, we'll move away from the law shortly, but based on the law as it currently stands, what sort of questions should a healthcare professional be asking their patient to obtain properly informed consent?
It's funny, when you as a patient sit in front of a good communicator, you know that you've got it. So I wish I could say to those listening today, so these are the 4 key things you need to do, or ideally 3. I always say there are 3 things in life. But I think the first thing is to ask the individual, why are you here today? Open question, and see what they say. And it may well be they say, because my tooth hurts. Okay, well, that's a good start. So can you identify the tooth? Okay, how long has it been going on? Okay. Then you examine, you then reach your diagnosis, there's decay. And then you set forward the options. And again, you've got to get that dialogue. So we can do this, we can do nothing. Patient says, I'm in pain, I need you to do something. And then you say, well, okay, these are the other options available. And have that dialogue. I could do this. Okay, that sounds good, says the patient. It's effective, but, and then you take them through the risks and benefits. How does that sound? I don't like it. Okay, next option. Go through them all. Make sure that the patient has those reasonable options available. And it's the classic thing that you get before you sign a contract, isn't it? If that cooling off period is needed, depending on how involved the treatment is, don't be afraid to say to the patient, I think you need to go away and think about it. Because I think, again, there can be a lot of pressure from patients as well as from clinics to get people through, to get people treated. But having spoken to professionals who end up having to speak to me, I would say that 99.9% of them say, I wish I'd just spent a bit longer with the patient on that day. Not that it's not pleasant speaking to me, but they have better things to do.
And the sort of the dynamics of that information sharing process change slightly, don't they, in an elective context where the patient is, say, going in for a cosmetic procedure and is looking to achieve a specific outcome from that. What would be your advice to a practitioner with a patient coming in and if I went in to see a cosmetic surgeon and said, I want to look like Brad Pitt?
You don't need to go there. You look fantastic as you are, Will.
Got a face for radio, thank you.
So managing expectations.
Managing expectations,
I think.
Exactly, yeah.
And I think we've seen it as well in the cosmetic industry, is the before and after photographs. I think when you manage expectations, you can say to an individual, okay, let's look at where you are now. Always, particularly with aesthetic procedures, where we're looking at changing an appearance, I would say a pre-procedure photograph. I'm sure we're going to come on to this, but you know, how to assist those who perhaps are being challenged with regard to the treatment they provided and the consent process. Documentation is key, and photographs to remind a patient, a client, what they looked like before the treatment and then after can be really so helpful, evidentially, for lawyers to be able to challenge allegations that are made. But I would also say that in terms of that managing expectations, whilst I'm conscious that in an elective environment, there can be the economic issues to manage, such as, you know, if the individual doesn't go for the treatment, then he won't get paid. But they need to go into that treatment understanding that there are risks. There are risks with everything. And I don't think practitioners should be afraid from showing the outcome of a bad hair transplant or whatever it is, so that a patient understands that not everybody comes out looking like Brad Pitt. They need to understand that it doesn't happen very regularly, it's very unusual, and it could well happen without any fault, because we know sometimes infection occurs through no fault of anyone. But as long as they have been informed and they have signed that, I'm going to probably come on to documentation consent form, which again is another invaluable piece of information, it becomes much harder for them to then challenge the poor outcome. And I think it's so tempting when things go wrong to say that you weren't advised of those risks, because you think, how could I have ended up like this? If only I'd known it could go this wrong, I'd have never signed up for it. And that's increasingly what we see. But the practitioner who has taken the time to go through the options has recorded the discussion they've had. And again, the time spent, the detail will vary depending on whether or not you're putting an injection in someone's arm as a vaccination versus doing an ankle replacement. It will obviously be very different. But documentation communication still vital and could really save you a lot of time at the end of the day were you to receive a challenge if the outcome isn't as the patient expected. And indeed, you expected. The amount of practitioners I think we've met over the years who've said, I didn't start my day thinking that when I did this procedure, it wouldn't go well. I always do my best. I always hope for the best. But I do tell patients there are risks, and sometimes they materialise.
Do you think that patients are now being better protected against undisclosed risks than they were before the changes in the law that we saw starting with Montgomery?
You very kindly didn't mention how long I've been doing this job, but I did have to look for another reason, and it's effectively 29 years.
Wow.
And of course, he then adds quickly, it doesn't show. But
I was going to say that's only one less than me.
But how interaction has changed with regard to consenting patients by medical professionals, but also how patients, I think, respond to that process has changed significantly. So I think if you were to ask, do you think it's changed for the best? I think, yes, it has. I think there's more information flow, there's better discussion, but I do think that it's still not quite where it needs to be. I still think there's a need for a recognition, I think, on behalf of patients as well as practitioners to really have that open discussion. And I think sometimes patients come saying they want a particular procedure and almost don't open up to a discussion about options. And then if it doesn't go well, they'll say, if only you told me physio could have resolved this, I'd have never agreed to go under the knife. And that isn't quite how they presented. They presented basically, some people come along, as I know when I speak to practitioners, and say, just fix it, or I want bigger lips, and don't actually engage in the discussion. So I think it is very much that communication. I think as a practitioner, you feel a huge weight and responsibility. But I think the patient client also has someone that, and if you're not content that they're listening, that they're understanding, because again, that's something you need to really be satisfied about. If you're not, then I would say, wouldn't I? Don't treat. Don't feel pushed into doing something that you don't think is right.
That's very interesting. And in terms of the healthcare provider, do you think as a result of the law, but also as a result of the way that the regulators have helped to educate professionals, that there is now a better balance in practical terms for practitioners around the consent process?
I think there is, and some of this I think perhaps is age related, and that makes sense in many respects, doesn't it? It's the way you're brought up. If as a child you were basically told, right, in you go, you're going to get an injection, and there was no discussion about it, that's almost what you expect. And ditto, I think, the training of practitioners, I think that's come on hugely now. Medical school, very much recognition of, patient rights, if you like, however you want to label it. But I think that sort of recognition that it is a communication, it's a two-way street, it is there, it's a good thing. And I do hope that those that are listening to this podcast come away feeling that it is a positive, and it's not just lawyers, again, making their lives more difficult and challenging.
And sadly, as we have alluded to, and as we both know very well, allegations about consent still form play a very prominent role in litigation against health and care providers. And we've touched on this earlier, but what in your experience are the sort of the key things that a healthcare professional can do to, I don't want to use the word protect themselves, I'll use the words protect themselves, but to address those allegations if they arise? How can they best evidence that they've had this information sharing process and that the consent has been provided?
Yeah, it's an ever-moving feast in terms of information. We already talked about information overload. And I know that there have been approaches of, the patient information leaflet, to the extent of almost it reaching a book. Anybody who underwent LASIK eye surgery will have seen, how many times have you signed a hire purchase agreement or a contract in a shop or whatever? And, the size of the print is so small, you can't see it.
Sign here, and here.
And you don't read it. Even as a lawyer, I didn't read it. So we know that forms and booklets and info in that form is of limited benefit. It's helpful to a degree. And I think, again, perhaps that timing issue. I actually had a case today that involved an orthopaedic surgeon having a consultation and giving the patient options and giving them an information leaflet to take away and read, and then to come back with questions at the next consult. Brilliant. Thought it was really good. Consent forms, again, we've all seen them. Simple, straightforward, addressing the particular procedure, very helpful. Again, notes, depending on the scale of the procedure. We've all seen shorthand. Some people dictate records, very helpful. I know some environments we have effectively the digital records, free text, great. Drop-downs can be a little bit of a risk because they are effectively almost standard. And I think one of my colleagues had a case whereby a child had been advised about not smoking and the child was 6. It isn't perfect.
Yes.
But it is, what I do like is if the patient has been asked about questions and the patient comes forward with the question and that is documented, that for me, that dialogue, communication is really helpful. I've mentioned photographs, very useful. And again, some practitioners, depending on the scale of the procedure, they'll actually demonstrate with a model. So again, what you'll probably see in the notes is surgery demoed on model or whatever. Again, that's helpful. The length of the consultation, I don't know whether people know that mainly in many GP surgeries now, effectively the time the patient comes in and the time the patient goes out is actually logged based on the practitioner entering the digital information on the record. So we know whether it's 10 minutes, 30 minutes, 2 minutes.
I always found that so helpful when I was advising on these cases, to have the length of the consultation documented. And I also found that when there had been communication direct with the patient, that was also extremely helpful. So if a discharge letter is sent to the GP, that could be helpful because that would evidence that, or may evidence that, a discussion about alternatives had been taken. But if a letter was sent to the patient, which set out in appropriate language, not medical language, about the discussions they'd had, then that was, for me, a real sort of gold standard in terms of evidencing that those options had been discussed.
Absolutely. And I think we've also talked about, in the aesthetic world, the pressure that comes with elective procedures. And I think we need to just be careful for those that are advertising, that we need to make sure that we're not over-promising what can be achieved with some procedures. And it's so easy to do. I mean, how many times are we all sort of scrolling through things and an ad comes up saying, wouldn't you like to look like this? I mean, we've already referenced my sort of age. And, it's like, yeah, I really would like not to have lines here, and that would be great. But photoshopping to suggest that I could look 20 again, I know that I couldn't, unless someone out there can suggest there's a way. So I think we've got, again, that managing expectations and being careful about what patients consider a procedure can achieve. So I think just be careful with your advertising as well, because once it's out there, information that you push out there is retrievable and can be used in a case against you. So just be mindful, I think, of what you're making available to the public in relation to the services you can provide.
If we're talking about the more sort of minor procedures, the non-surgical cosmetic procedures, where one wouldn't expect, as a matter of course, there to be a clinical record of that procedure or of that treatment, and a lot of the communication around the benefits and risks of the treatment would be in information leaflets and so on. Do you see a value in including a tick box within that documentation to the effect that somebody has read and understood it and had the opportunity to ask questions?
I think it is still really helpful. There are various ways of trying to make that process more interactive and also recordable, if you like. So I know that various organisations have tried a interactive animation. So you log on to a link and it basically says, here's Vicki. Vicki has lines around her eyes, what are the options? And, you click on to the next screen. So there is innovation coming in with the processing of these sort of aesthetic cases, which I think is great. So forms, ticks, useful. These perhaps interactive animations, again, very, very useful. And I think we also need to be careful about, you've mentioned clinical records. What I particularly see in that aesthetic world is WhatsApp messages to your practitioner. Saying, hi, Valerie, thanks for doing the procedure, but I've got a bit of pain. Oh, sorry, Val, do you want to pop in tomorrow? Well, actually, that's a record of an issue that's arisen following the treatment and your response to it. How are you going to store that? How are you going to make that available to me when, unfortunately, the client 6 months later says, well, actually, because you didn't address that problem, I got infection and I had huge issues and I couldn't work for weeks and I now want £20,000. Thank you very much. So I've seen that. And I think that is a challenge because of the way we communicate now and that sort of doctor-patient relationship. The lines are getting much more blurred, I think, perhaps in that aesthetic world. And you can feel very much a friend, which perhaps makes it even more hurtful when that friend turns around and starts criticising what you did. But it's a business relationship as well as a practitioner relationship, and you need to store those records and I think always behave in a professional way.
Thank you. That's very interesting and maybe a topic for a future podcast in its own right, I think. So just to wrap up on consent, do you see what's happened this year with the Mulloch case? Do you think that's going to lead to an increase in allegations of consent or failure to obtain consent in cases? Or do you see that as something of a more welcome clarification of how the process is intended to work and how the law works around the process?
I think it's the latter. It's a clarification, and I think it is helpful. I think many practitioners, when the decision came out, sort of sigh of relief. It was sensible, practical, reasonable. In terms of consent allegations in claims that come across my desk, I still see them with more regularity than I would like. It's a bit like periodontal treatment. Most dentists will say to you it's the most preventable condition. You just tell the patient they've got to clean their teeth better. And as long as they keep doing that and then respond if the patient doesn't do that, then you've really done your job. And it seems quite straightforward. So I think it must be frustrating for practitioners to face these sort of criticisms because it is, I think, preventable and defensible as long as you say do that communication piece, have that conversation, and as every lawyer will say, keep good records.
And if you do that, the courts are likely to support you.
Yes, and I'd reassure people listening, if you are a practitioner, most cases don't go to court. The resolution of cases is generally achieved before we get to that point, in recognition that it's a very costly and time-consuming process. And hopefully, again, through lawyers communicating with each other, we can avoid having to put practitioners through that.
Well, it's been an absolute pleasure talking to you today, Vicki, and thank you so much for your time. And I'd like to thank you on behalf of all the Altea customers for your insights and for sharing your expertise on consent with us today.
I've really enjoyed it. It's the first time I've done a podcast, so thank you for asking me.
It doesn't show at all. Thank you. Thank you for tuning in. I hope you enjoyed today's episode of AlteaTalks. If you did, please don't forget to subscribe or leave a like or a review on whatever platform you're listening on, as this helps spread the word. If you have any questions or comments or topics you'd like us to explore in future episodes, please do contact us, as we'd love to hear from you. You can find us on LinkedIn or visit our website at www.AlteaInsurance.com. Stay tuned for more episodes, and until next time, take care of yourselves. The information contained in this podcast is not intended to represent a complete analysis of the topics presented and is provided for information purposes only for practitioners in the UK. It is not intended as legal advice, and no responsibility can be accepted by Altea Insurance or DWF Group for any reliance placed upon it. Independent legal advice should always be obtained before applying any information to particular circumstances.